No, they're going to try to interact with you.
Or you.
I'm not going.
Oh, okay.
I've had my fair share of jail now.
Yeah.
So one time I went, that was small experience. I'm all done with that.
Boy, I'm popular for you.
The only girl in the boys' jail.
Yeah.
All that thing. That wasn't fun.
So today we'll do the cases that were on the syllabus for Tuesday. The Jim cases, Brasher, Worcester, Yale, Oscar, Lawrence, Angela, and Hillary, and talk a little bit about Jin's cases in comparison with the C&P cases that you've done up until now, and then maybe if I get a chance, I can do a little comparison chart for you there on the board in terms of their similarities and differences to the delinquency cases too. So let's start with Brasher, Commonwealth v. Brasher. I love this case. Why do I love this case? There's a really funny quote. If anyone can find it, I'll give you extra points. No, I'm kidding.
Corporal punishment and whipping.
Everyone's looking for it now. We're starting with Commonwealth v. Brasher, Karen, and I just said I love this case because there's a funny quote in it.
If you find it, just give me $100.
Oh, no! First it was points, but you'd rather have money, huh?
What do I get? Money? $100.
Sure. I've got some land in Fort House,
So your friend Michael,
Yes.
he was wonderful.
He was very good, wasn't it? Michael, he currently has an MSL student interning for him who will stay with him through the summer, but just keep that in mind. Michael does take interns almost every semester, so just let me know in the future if you're interested. He's in the Malden area, but he bounces around, he goes everywhere, so.
She used vile and vulgar language of a kind formerly used only by common railers engaged in gutter brawls.
That's it! That's it! Okay, so tell us about the case now.
That's my reward?
That's your reward for finding the quote.
All right, so it was a girl that was disobeying her parents.
Her parents?
I mean her mother, was it her
Where was she
foster?
living?
Her foster. A home.
A home.
Yeah, it was like a group home, right?
You were busy finding the quote, Ginny.
I know, right? Now I have to go back to the beginning.
So what does that mean? You got to the quote, and really that's the heart of the case, actually, as well. She used vile and vulgar language of a kind formerly used only by common jailers and railers, I can't read my own writing, and engaged in gutter brawls, right? Is that what the quote says?
Yep.
Okay. So what does that mean? What did she do?
She was disobeying.
Who did she disobey?
The people in charge of her. I thought it was her parents, but no, sorry, not what the house mother. Yeah. So it was a group home, like a foster home. And then she was like being vulgar, and she would leave when she wasn't supposed to leave the home. Yeah, she was.
She sounds like a sorority sister.
Yeah, but she was in high school, so she wouldn't have been. Yeah. Hey, we were all behaved. Yeah. And so yeah, so she would be out hanging out with guys and she wasn't, so I'm guessing that means that she was probably an all-girls home. And she would not be, she wasn't listening, obeying commands that were given to her, so I think it was a group home. I can't find who she lived with, yeah.
Look at the name of the case, Commonwealth versus Brasher,
She was in custody.
and the year of the case.
71.
Anybody know the meaning, consequences, or why I gave you this case as the beginning of the Chins section?
Well, isn't that one of the first cases that determined what a Chins petition was and outlined that a Chins, another Chins person is one who's stubborn and defiant and basically, this one that just set up basically the definition of Chins petition.
It set out something, not necessarily the definition of a Chins petition. There were no Chins cases at the time.
Was it
And that's the reason the name of this case is entitled Commonwealth v. Brasher. So the Chins statute is really kind of fairly new in the scope of juvenile law. And a statute that pretty much attempted to decriminalize. Remember that Michael Kilkelly referred to it as the status offense statute. So it attempted to decriminalize behaviors of children that weren't really criminal, but weren't really good for them and for families and so forth. But back then, the term stubborn children were used. That term is still used in the current Chins statute. The elements of what this child did back then also sort of mirror the elements of the Chins statute today. Amy, you had your hand up for a while.
No, because it stems back to the colonial law back in 1600s. So it's bringing it, it's always been wrong from day one to now.
You may have heard the term, wayward children, stubborn children. Geneva?
So it's, was it our probation officer? Because she was in the Department of Youth Services, and she was placed in the home of a named individual at Lowell.
She was what?
Placed in the home of a named individual at Lowell. I don't know.
Oh, okay. You were still trying to find the home all this time.
Yeah.
Very excited that you found it. All right.
The deaconess home.
Yeah.
The deaconess home.
Yeah. So what are the elements? Because that again, that piece of the case is what's important to us. So what are the elements of a child who disobeys the lawful commands of whoever the parent or parental figure is? Leslie?
Well, I think, I'm not sure if I have, but a child below the age of 17 who persistently runs away from the...
Okay, wait, you're reading the statute.
Yeah.
Okay, we're looking at the Brasher case that set the standard for later on the statute. So what are the elements of a stubborn child from the Brasher case, Leslie?
Okay, that a person having authority to give a child under the age of 18
Right.
lawful and reasonable commands,
Mm-hmm.
which such child is bound to obey, gave such a command to a child that the child refused to submit to the command, and the refusal was stubborn in the sense that it was willful, obstinate, and persistent for a period of time. The person giving the command is usually one of the child's parents, but it may be another person.
Okay. The willful is another term that you see in today's Chins law as well. So what else does this case tell you and help you in terms of defining what a stubborn child is? What is a stubborn child not?
Well, it's not someone who does it infrequently.
That's right. So if it's once, supposedly, single, infrequent, etc., as you say, another rationale, another rule from this case that still is good law today. Anything else?
Had to be beyond a reasonable doubt.
Amy, what?
Had to be beyond a reasonable doubt standard.
Oh, you saw what I put on the board.
Oh, yeah.
Is that where you're going with that?
No, I pulled out that there was, the standard was assigned that it was beyond reasonable.
Yeah, one of the questions I was gonna ask you guys before, and I'll actually, we'll compare it to, you've done the parent protection cases, which, allegedly civil, as Mike says, and as much to Leslie's surprise, that the whole juvenile court is civil. Yes, that can be disagreed. The burden of proof for your parent protection cases was clear and convincing, right?
Yes.
Which is a little bit more than the ordinary preponderance standard, which we saw at the 72-hour hearing stage. But you're right, the burden of proof for chins, which, again, the chin statute that I just said, supposedly decriminalized, is a criminal standard of proof beyond a reasonable doubt, and it made its way to the statute as well. That's where you were going with that, Amy? Okay, yeah. And it's also later on when we do the delinquency and youthful offender cases, the same burden of proof beyond a reasonable doubt. Okay. So the next older case we have, it's even older than Brasher, is Commonwealth v. Johnson. So why are we reading that case? So how the Brasher case was initiated by the group home who contended that this little girl was using vulgar language, etc., not obeying the commands of the home. So who initiates the Johnson case?
The school.
Leslie?
The
The
school.
school. Okay, all right. And what was the basis of the allegation?
Persistently violating reasonable regulations of the school they attended because these kids wouldn't salute the flag. They refused to salute the flag because of their religion, I guess. They were Jehovah's Witnesses, and I'm pretty sure I read, I read the case.
What was the term used allegedly for the group of children that habitual school offenders? So why was their refusal to salute the flag? I'm sorry. I'll never live this one down.
It's on tape.
Oh, yeah. Do you hear it online, students? That's all right. I'm the advisor to the Diversity Alliance, so I
Right
can
on.
use those terms. I'm not going to say it again because I'll slip again. So what did the SJC hold? Easy to ask that question.
The SJC said that the statute does not expressly impose a duty of compliance with instruction given by teachers for breach of which they would be subject to penalty.
What does that mean?
So the statute didn't specifically say that when kids disobey their, school authority, that they would be punished for it. It didn't spell out that, I guess.
What's another way of putting that, and how would you encounter something like that today? Whether the school possibly could be, bringing a chins petition alleging that a child is not obeying the lawful and reasonable regulations of the school, but the child has some defense to it, like the children here.
Due process, like they want notified?
Okay, it's something similar to what we read about earlier when we were doing some of the student cases in the beginning of the semester.
Dress code.
The dress code, so First Amendment issues, okay? So keep that in mind, again, in terms of defenses to the bare words of the statute. when the school alleges, you know, you haven't obeyed lawful and reasonable regulations of the school, and, you know, you saw it in the handbook or whatever, but the child may be alleging some sort of, some way that he or she can be possibly taken out of the realm of the elements of the Chin statute. And we'll see that with some of the hypotheticals we're going to do next week. The Hallie Wright case that you have on your, I believe you have in your materials. I'm also going to send you a hypothetical case that we're going to work with that has to do not only with the Chin's issues. I said I would come back to gay student rights, and so in terms of bullying and so forth, I'll be sending something to you guys by email that we'll possibly do for Tuesday or Thursday of next week. So that's the Johnson case. School Committee of Worcester versus the Juvenile Court. So far, we're not seeing a strict Chin's case yet.
So if they're not considered Chin's cases, are they considered delinquency?
No, we're looking at School Committee of Worcester versus Juvenile Court, which is what kind of case? Mark?
I don't have that one.
So the two previous cases were criminal cases. They predated the Chin statute. So again, before there was a Chin statute, there were similar subject matter kinds of cases. But these kids were dealt with just like the delinquent kids that actually committed crimes were dealt with. Now we're looking at a civil case. How did this case start, Joe?
This case started, this is actually a Chin's case. They used the statute.
Oh, okay, I'm sorry. It was a Chin's case?
Yeah.
Okay, that's why everybody's looking at me like crazily.
This is the case where a child brought a weapon to school and gets expelled. And the court's going to look at whether or not the Chin statute allows for the possibility of expulsion.
The Chin statute, why don't you concentrate on the authority of the juvenile court and what the SJC said about the authority of the court?
But they held that the juvenile court didn't have the authority, either expressed or implied, to determine the constitutional.
Just back up for a second. So how did this case start? What was the school policy?
School policy was that bringing a weapon to school was an automatic expulsion.
Okay. And then what happened next?
The child brought a weapon to school, got expelled.
Okay.
And then there's an appeal, there's a hearing to see whether or not the expulsion can be overcome. And the juvenile, on the lower level, the juvenile court judge said that the standard was, that the rule was unconstitutional.
The juvenile court said that?
Right.
Okay. And did what?
And ordered reinstatement. Yeah, ordered the reinstatement of the juvenile.
As, in what way? In terms of the Chin's proceeding before the judge? Karen?
I'm sorry, what exactly is the question?
So this is the juvenile court judge that was
Right.
hearing the Chin's case,
Yep.
correct?
Yeah.
Okay. So tell me about like the judge's order, how the case came before the judge, and then what the judge ordered as disposition.
Well, the case
That-
came before the judge in juvenile court in February, and
Mhm.
then the knife incident was in October. And so
Okay,
then
good.
Then they had a hearing on the Chins in November, and the judge adjudicated the child in need of services at that point, and then in December had a dispositional hearing.
That's what I'm getting at, okay?
And that's when they were deciding basically what to
What are we gonna do with this kid, right?
the kid. And that's when the judge decided that the kid should be reinstated into school, and that the school committee's policy was unconstitutional under the state
Okay,
constitution.
all right. So now we're getting to what the SJC held and why. Sandra?
I
after they were reinstated, then the plaintiff filed a motion before the juvenile court. They wanted a stay of the appeal, and the judge denied that motion. Because of the, I believe it was a statute, because of the 211 Section 3 statute, I believe.
Well, 211.3 was the vehicle to go to the appellate, the highest court, or the appeals court. It can be used either way, right? So keep going up the ladder, Sandy.
Okay.
What does the SJC end up doing? This becomes important later on too, for all the things that a juvenile court judge can or can't do in relative to Chen's cases. Stephanie?
Well, it said, like, in one of their arguments, they were talking about 119 Section 39G, which provides the jurisdiction for the ruling and the dispositional order. But
yes.
What the court said here was that although they can authorize an order, they can't. It said, we conclude here that the language of 39G authorizing a judge to make orders determining custody and placing limitations on custody is not broad enough to authorize a judge to raise and rule on the constitutionality of school policy. And then they can't order the school committee directly to reinstate an expelled juvenile on that basis.
When you say they, you
the
mean
court.
The juvenile court judge?
Yes.
Okay, good. Geneva, you want to add to that?
I was going to say, adding to that they can make orders determining custody and they can place limitations on it.
The juvenile court.
The juvenile court.
You just say the juvenile court judge or the juvenile court instead of the pronoun.
Can make orders determining custody and they can place limitations on the custody, but they can't.
The judge.
The
juvenile
judge
court.
cannot force you to
Who's
do
you?
something.
Stay away from the pronouns.
The juvenile. They can't force the juvenile to attend school, or they can't force the school to change its policies.
You can say they, but that's
I'm done.
Okay, so we've seen one limitation here so far on the authority of the juvenile court. I'm going to skip, I don't know what's the matter with me today. I'm going to skip over Gail because it's been pretty much eroded by Hillary. Let's do Oscar. This is another authority of the court. Stephanie, you want to do that?
Yeah, because this one was a short one, but this one determined that the judge cannot order private education. I think, I'm pretty sure. Oh yeah, so they concluded that no provision under, this one is chapter 119 again, either section 39E or 39J. It doesn't grant the juvenile court authority to order special education assignments for the juveniles. And here they ordered him.
Yeah, I was just going to say, what kind of Chin's case, how did this begin?
Well, there was a truant officer brought the petition, and the judge, so yeah, the truant officer brought the Chin's position, and the judge at the Chin's proceeding ordered that Oscar be enrolled to Landmark School in Beverly, and that the county of Worcester was going to pay for the schooling. And then, so he attended the school from March to June.
Oh, hold on for 1 second. So, what else did the judge order in terms of custody? So where was the child? Where was the child living?
He was 13 and living with his mother.
Okay. And not going to school?
Yes.
Right? And then?
Yeah, so I think the only assignment that they gave him was that he needed to go to the private school, that he could remain with the mother.
Okay, but back up again for a moment. So the case comes before the court, and so when the juvenile court is going to adjudicate the child a Chin's, then there needs to be some sort of custody order, right?
Yeah.
You jump to what the judge did that the judge shouldn't have done, was to to direct that particular kind of placement? But whose custody did the child end up in?
With his mother.
That's,
Yeah.
that's what I'm trying to get
Yeah, no,
at.
I said he remained with his mother.
Okay, and as a condition?
As a condition, yeah, he was to
Okay,
go to the
that's what I'm
school.
trying to get you to get.
Oh,
to
okay,
say.
sorry, condition.
All right. So it's, I'm adjudicating you chins because you didn't go to school, you know, or it could have been, you know, not after trial, but as a stipulation of the parties, but I'm adjudicating you chins. I'm putting you in the custody of mom
As
or
long as
dad,
you
mom and
stay.
dad. So those, the adjudication's okay, the custody order's okay. What's not okay is then saying where you're gonna go and who's gonna pay for it, right? And then we have two more cases, Joe.
I have a question. Is there a difference between physical and legal custody in this case, or is it the same? That's what I'm trying to,
Yeah.
it sounds like
It's the
legal
same.
custody is almost with the department, and they're granting it to the mother, but.
No,
okay.
and we're gonna get to that when we discuss Hillary and the department's involvement. But notice I put on the board too, that, so in the CMP cases that you dealt with, when the parents lost custody, for the most part, because anyone could petition, right? But usually if it's the department, it's the Department of Children and Families that is the agency that's involved. Now, with your chins cases, and let me somehow put somewhere on the board, remember they're coming into juvenile court based on 4 sort of subject matter scenarios, right? The Brasher case that you looked at, right, was the child who refused to obey the lawful and reasonable commands at home. Okay? So parent, refusal, blah, 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 to obey. It's the petitioner, okay? Somebody give me another one.
Runaways.
Okay, so parent might be calling police. Parent, police. The child has run away. Okay. School.
Truancy officer.
Okay, now we have the school. And it could be for what?
Truancy.
Truancy. And the last one is also the school, right? I'm not gonna say habitual school offender, because that is still kind of an old term, but when you look at the statute, what's the language, the lingo in the Chin statute? It's the child who does what, or doesn't do what in school. Jamie?
Obey the rules or the
Persistently refuses to
policies.
obey?
Yeah,
Lawful.
disobeying lawful, reasonable regulations of the school. But in all of these, and again, if they're straight chins, and we'll encounter at some point chin/delinquency cases. But if it's just a straight chins case, a child who's either disobeyed at home, disobeyed at school, run away, or not gone to school, worst case scenario in terms of custody is what? Where's the child gonna go? Tanya? I can't hear you. That's why you're whispering, you're not sure. So what agency up here, what agency is involved with chins? DCF. Allegedly, their status offenses, still civil, again, but you're seeing aspects of criminal, like the burden of proof beyond a reasonable doubt, you know, the runaways that can be, you know, detained and so forth. So there's other aspects of the case being criminal. So the agency can be DCF, but in most of these cases, just as Geneva mentioned, or was it Stephanie that just did the last case? I don't know what Stephanie did. Custody is going to parent, and there might be conditions of custody. So, Karen A., what was the Vincent case about, again, in terms of custody of the parent and the juvenile court's authority? How did the Vincent case start? What kind of what kind of Chin's case was it? Okay. The other Karen wants to do it? And I guess, all right, I'll come back to you for Florence then. Go ahead.
Okay. It was willful and persistent failure to attend school.
Okay. So the Chin's case was started by the supervisor of attendance. Kid goes before the judge, right?
Yep. And the judge keeps him in custody of his parents.
Yeah.
And tells him he needs to go to school. And then threatens him to put him into DYS custody if he doesn't.
Yeah, that was basically it. And you can picture it. This was Judge Vasili, who I remember. So he sees this kid again. He says, "What are you doing? I told you could go home with your mom. I'm putting you in DYS if you don't go to school." So what's wrong with doing something like that in terms of, again, the juvenile court's authority?
Well, that's overstepping the authority because, well, and the way was, it was, he was held in contempt of the court, which is a criminal sort of a thing, and the judge in the juvenile court did not have authority to do that. It had to be conditioned upon custody.
I think you're talking about the Florence case. When you said contempt.
I think it says it here.
Does the Vincent court uses contempt language?
Yeah.
Because I thought Vasili was just yelling at him about going to DYS.
No.
Okay.
Now they use contempt.
Okay.
Florence, the Florence one too.
Yeah, the Florence one too. Okay.
Yeah.
So here's the question now. So you have this statute that's meant as a prophylactic device, to prevent children from ultimately committing crimes. Also meant to decriminalize behaviors that are not criminal, but could ultimately result. So kids that are acting up at school, not going to school, not obeying their parents or the school system, running away. There've got to be reasons for that. And if we offer them services, then maybe they're not going to engage in criminal behavior and whatnot. So the children come before the court, and the court really can't do anything about it. It's been criticized as a statute with no teeth. Maria?
But from reading this case, what I don't understand is that, or maybe, what's interesting is that the kid was doing good, he was complying with every other services or conditions that they identified, but his only issue was that he was refusing to go to school. And then they
His
wanted,
only issue.
Yeah. And then they wanted
You're good in all other respects, but so we'll overlook that you're not going to school.
Yeah. But the thing is that they were talking about DYS, committing him to DYS, and they sent him to DYS for 30 days, where DYS doesn't even have a school component. So then, I don't know. But
Yeah, that's a very good point, Karen.
See, I can see the rationale for the statute, because what they're saying is, if you as the parent can't get your child, that's your responsibility. So if you can't, we'll leave that child in your custody if you can get that child to go to school. Otherwise, we're gonna take the child and put them in, and while they're in custody of DYS, if they're,
Hold on a second, because remember, what I've got on the board here is that the only agency, no matter how bad the Chin's kid is, say the Chin's kid does all of these behaviors, keeps running away, doesn't go to school, doesn't obey at home, doesn't obey at school, all right? They're not criminals, so DYS can never be involved.
But they go to DCF.
DCF,
They go to
okay.
DCF. So they go to DCF, and I'm not saying I like this. This isn't a, but
Mhm.
DCF then they're gonna force them to go to school, and the child may then go to school because they want to go home. You know, and if they understand that that's really the consequences of this, I can understand the.
And that is the sort of worst case scenario, that the child would be removed from the home. And, you know, thus we get into some of the later cases that recognize both the liberty rights of the children and families and the parents as well, in terms of the loss of custody that results from a child's actions. The other thing that I wanted to mention about these cases is that, you know, the care and protection cases, the parties, who are the parties in the care and protection cases in terms of the whole right to counsel issue? Actually, hold that thought when we get to Hillary. So let's do Florence because it's just the companion case and so closely aligned with the Vincent case. And Karen A., you said you would do Florence?
Well, and this one is very similar.
Yes.
And but they talk more about the judge issuing a contempt order, which is a criminal order.
Yes.
When the child doesn't comply with what the judge had ordered before. Because we know when you don't comply with an order of court, you're charged, it's then criminal. But they say that the judge, that doesn't work.
And it doesn't work basically because what? What is contempt, and why does contempt not belong in Chin's court system?
Because GL 119 doesn't, and case law also, doesn't give the juvenile court the right to order direct orders in Chin's cases.
Because it's not criminal.
Well, the judge can't order them.
Well,
to
it's
school.
because it's not criminal, because the contempt
The order itself is invalid.
is based on a criminal issue, a criminal proceeding. So we get out of this again that a Chin's case is not criminal according to Florence, because it's saying that the juvenile court judge can't use the contempt procedure because the case isn't criminal. Yet again,
Why can't you use civil contempt?
What's that?
Why can't you use a civil
Yeah,
contempt?
well, what's a civil? Yeah, that's a good.
I mean, there are ways that in other court proceedings, just to give it some teeth. I mean, why couldn't the judge actually be able to order something? I mean, it seems that's what the case is saying it can't do.
It can't
I don't really
do.
understand.
It can't do. And again, going again to the overstepping your bounds as the juvenile court judge.
Isn't it because they
and
can't issue direct orders?
Yeah, yeah.
What
Geneva.
if you violate the condition of remaining with your parents, so then they give you to DCF, and you still don't go to
Wait,
school?
say that again.
What if the court gives an order with a condition, like you have to go to school and you can stay with your parent, and then you don't keep going to school, so they take you away from your parent and give you to DCF?
DCF, yeah.
So
And
then
you-
what happens if you continue to not go to school? Nothing?
You keep, you sort of keep coming back.
But nothing ever happens.
You're getting it.
I mean, it depends on what's going on.
It does, it does,
It
it
could
does.
turn into a care and protection. If the reason why the kid's not going to school is really more an issue
Absolutely,
related to the fitness
absolutely.
and what the parents are doing,
But
which
still nothing happens.
9 times out of, well, yeah, no, everything happens to the kid because then they're the one that gets removed from the home. They're the one
Absolutely.
that gets placed in foster care.
But they've already
And
been-
if they
like raising-
don't, and then if they don't follow the rules, then it's on to group homes and then residential
But, yeah,
treatment.
and what you're asking, Geneva, essentially is nothing happens in terms of there's no sort of change in custody.
Well, that-
Because the only possibilities in terms of custody are family or some type of family and DCF.
But I mean,
It's
let's-
never gonna be DYS. And again, the court can't issue the direct orders, the court can't deal with the child criminally. Remember the term child in need of services. And again, that was like, you know, the goal of the statute. Let's see if we can offer services to these kids.
But it can't
you know.
possibly be as traumatizing because this is the child's fault.
I'm not understanding you. Be
like
careful in terms of traumatizing. The reason why one of the reasons why I put this all three actions on the board as well is I'm dealing with it for class discussion purposes as, you know, sort of by itself as a CHINS proceeding.
Right.
So many of these cases overlap. So for example, as Karen pointed out, you may have the child who's not going to school or who's disobeying or engaging in behaviors that could be bullied, could be abused or neglected by the parents. Someone's ultimately going to file a 51A. There's going to be a parent protection case. The child could then perhaps you know, get more services or different types of services. On the other end, the child could be engaging in behavior at school that ends up also being criminal behavior as well. So you could have the school starting a CHINS case, but you can also have the police taking out a complaint, or parents taking out a complaint and it proceeding through the juvenile court as a delinquency as well. So and the weird thing is sometimes you have actually different attorneys. Sometimes, depending on the attorney's capabilities and what they're certified as, you might have a CHINS attorney for a child and a delinquency attorney for the child based on, you know, almost sometimes the same sets of events. What did you say, Karen?
If you're lucky, actually, because I had a case that was in probate court, and then it was in CHINS,
Oh,
and then it was
probate.
a Karen protection, and it was still probate. After a while, we got rid of the CHINS, so we were down to just probate and Karen protection, but then we had the probate attorneys representing the parents in the juvenile court, which actually was not beneficial to
I
any
can
of
see
us,
that. I can see that.
Because, you know, the rules in the two different courts are different.
Very different.
So, and when I've had cases that have delinquency attorneys dealing with the delinquency part and Karen protection attorneys dealing with the Karen protection part, it tends to work out better, I think, for the kids.
And sometimes too, you know, depending on the case, depending on the attorneys, depending on the district attorney, you might, if you have a combined delinquency CHINS case, you know, you're thinking about, well, what's the best dispositional alternative you can get for the child to not have DYS involvement, to not have a finding of delinquency, and sometimes you can actually achieve some sort of stipulation agreement to work with it as a CHINS rather than a delinquency. You know, either quaff the delinquency, you know, or get the delinquency dismissed, you know, because it might have been based on, you know, CHINS behaviors that really need some services and whatnot. So again, I realize that, you know, for class purposes, you know, we're looking at cases that by themselves either were CHINS cases or have CHINS issues. But when you're practicing, you know, you might have that overlap between all of these things going on at the same time. And they get crazy.
Yeah, I'm just trying to say, like, say you did just have the CHINS issue, so you're just like a bad child. Like, you just disobey your parents. It's not like your parents are drug addicts or abusing you.
Yeah,
Nothing
and that can
happens.
happen until you're 17. Or that can happen for the Angela case. Now remember, these are only good for 6 months. So once you're adjudicated, you have to be re-adjudicated. Angela, yes? Did you have that case in the reading for today?
We did.
Angela?
Yep.
So when the judge makes, the juvenile court judge at the first CHINS hearing where a child is going to be adjudicated a CHINS, again, you know, there's the adjudication, there's the custody order, there's the dispositional alternatives, and again, it's the court system coming up sort of with a plan to address the needs of the child. So 6 months later, the court then has to look at that again. So what was happening before Angela that was wrong? Anybody tell me? Joe?
I think,
Okay.
what I got out of the case was the fact that the burden changes from the first hearing where the burden is beyond a reasonable doubt to that after the 6-month hearing, there's a different standard because you're not looking at the original issue that brought the case in front of the court. You're looking to see whether or not it was successful.
That's true, but you didn't answer my question. You did mention what the standard of proof should now be according to Angela going forward. But going backwards, so you had the kid who had been truant, all right, and placed it, you know, says, okay, stay with parents, all right. 6 months later, that order's gonna expire. Before Angela, what would the court do in terms of the hearing? Don't laugh out loud, Karen. What did the court do before Angela?
Do you mean after the end of the 6 months?
Yes. So your kid is, you know, under the jurisdiction of the court, Chin's order, all right, so the Chin's case is open. It's now 6 months later, you know, you have today is Thursday, April 5th. You have to appear, okay, you and your kid. You're gonna go to court on April 5th, and the 6 months is up. You're gonna have a hearing before Angela.
No,
I think it just ends,
just
right?
keep going. Yeah.
And the judge says,
Okay.
hey.
Hi, how are you? Is she going to school? Well, she's really not. Okay. Well, let's continue it. All right.
So now the judge has to have an evidentiary.
Exactly. Exactly. And what's the purpose of that evidentiary hearing? In order to extend that order, Amy, what does the judge have to be satisfied of?
That the child is still being willfully not going to school and not abiding with the orders.
Well, put it a different way, because again, we're thinking of the services and what the ultimate goal of putting that child, of adjudicating that child in a Chin's in the first place was. So we're sort of reviewing, Mark, what the child is.
The purpose of the 6-month hearing is to determine whether it would be reasonably likely to further the purposes of the original order.
Simply put,
Mm-hmm.
that the
Yeah.
purposes of the dispositional order have not been accomplished.
Yeah, so, you know, oh, she's doing great, she's going to school, et cetera. Oh, she's, you know, then maybe you're gonna get it dismissed,
That's legalese.
right? What's that, what? What's legalese?
No, so we were just.
You said both parts were in the sentence, so you guys both got it.
Right.
And don't you think that becomes frustrating for the parents if it does get dismissed? Because you've got a Chin's in place and it's doing all the right things for the child, and all of a sudden, oh, he's doing all the right things, let's pull it now.
Uh-huh,
I mean,
that's a
to
good
me,
point.
that's frustrating.
It's like, yeah.
But then what they do in that case is that they dismiss the Chins sometimes, but then they get the case open to the department, that if anything comes up, they can go in and, you know, depending on the age of the child, and reapply, you know, reopen the Chins.
If the department's involved.
If the empowerment, right.
And the
I'll use an
department-
example, my son was on one.
Oh,
So
good.
it was so frustrating for me and my ex-husband, because we went and we got the Chins put on him. I mean, and I'll tell you, they gave him a tracker, and they gave him more help, and he was doing so well, and all of a sudden you pulled it, and he went downhill again.
Cause you went to the 6 month
Right.
and it was done,
And we had to go through the whole
right?
thing again to get him back on one. I mean, it was the best thing that happened to my son today, but I mean, it was just the fact that we had to go through it a second time because they pulled it. Like, it was so frustrating. The tracker was the best thing, they put him into counseling. You know, the tracker would go to his school and check on him all the time. He'd come and take him out to play basketball, that type of stuff. Stuff that my son seemed to need because me and my husband worked a lot at that time. So, I mean, it was so frustrating that we had to go through it again. Like, the 6 months was up, okay, we're all
That's right.
finished, and then 2 or 3 months down the road, we had to do the whole thing all over again.
And you started, so you were the petitioner in this.
Correct.
In this case. And whenabouts was this, in terms of year?
Prior to Angela, it was,
Prior to Hillary? That's
Yeah.
what I'm getting at,
Yep.
okay.
Mhm.
So
Yeah, my
for-
son's 18 and he was 13 at the time.
Okay. So another big difference up until Hillary, so in the care and protection cases, you have, you know, parents getting counsel, right? Children getting counsel. prior to Hillary, Chin's case starts, and by the way, this is another sort of muddying of the waters in terms of procedure. With the care and protection cases, once the case started, you had an attorney for the state that represented the petitioner, that got the ball rolling, so to speak, that, you know, ran things in terms of the state. So you had parents, children council, DCF council. Okay. In all of these cases where parent or school system were petitioners prior to Hillary, the only attorney in the room, in the courtroom, is who? The kid's attorney. That's it. So the petitioner, who's not a lawyer, has to also abide by a criminal standard of proof, and so that, you know, why are you laughing?
We saw a truant officer who seemed, he really knew what was going on. It was as if he was an attorney.
Yeah, because they obviously get to know
We're trying to figure out,
the regulations and
was
what's.
he an attorney, was he not an attorney, and it, you know, I don't think he was, but it took us a while because.
Yeah. And technically, it's the supervisor of attendance is the person that starts off the case on behalf of the school, whether it's a disobeying school orders or a truant type of case. So, what happened in Hillary that really changed it in some ways? By the way, you know that Michael Kirkelly was appellate counsel in both the Angela and Hillary cases. I spoke to you guys. Okay.
So he was the counsel for the case?
Yeah, in both cases, and he was the counsel in the Robert case, that way back when you read about the preponderance of the evidence standard at the 72-hour hearing. He was appellate counsel in that case as well. He was responsible for changing the standard, the 72-hour hearings. Leslie?
Well, I know, I read the case, but I just made notes, so I don't remember the facts, but I know that the whole idea was, it was a matter of first impression, and for the first time, the court said the parent was entitled to counsel at the dispositional phase of the proceeding if custody was at issue. Once a child is adjudicated a child in need of services. So if they were gonna remove the child, I guess, then the parent was entitled to have a lawyer by the court, if they could afford one.
Okay. So what does that all mean in the context of the arguments, the early cases that you guys read about parental rights? Why is that? Why does the court ultimately make this decision?
The court felt that the parents have a fundamental liberty interest at stake. And when a child, in this case, a child was placed in a foster home subsequent to a care and protection proceeding, and then she ran away and a hearing on Chin's resulted. So the child was entitled to counsel, but the judge denied the mother counsel. And in the end, it was determined that parents do have a fundamental liberty interest in the care and custody and management of their children. It's a due process issue here. So when a child is entitled to counsel, so are the parents at a Chin's dispositional hearing.
So think of in what scenarios or for what reasons do you think that a parent would want to have a lawyer represent him or her in any of these 4 types of Chin's proceedings?
Well, like if the parent wanted to didn't want to give up custody, wanted to.
So Leslie's saying in a situation where parent would be fighting with DCF, who doesn't want DCF to now enter the picture, and that would follow for what Mark just said, that there's a potential loss of the 14th Amendment rights to parents.
Because they're basically losing the control of their child, and it's got nothing to do with their fitness as a parent, and it really does kind of involve it as their fundamental liberty interest. And they are, like you said, would be fighting the DCF, who could get custody of the child legally. So she's entitled, or he's entitled to an attorney, a the parent.
I agree with Mark. I think that you'd want an attorney at all of them. I mean, if it's the parents asking for the petition, then you're just asking for services, saying that you need help because, you know,
What
my
if you
child
need
might
some
want
help
to-
so bad that you've had it with this kid, and you want DCF to have custody?
Well, then you can waive your right to an attorney.
What's that?
Then you can waive your right to an attorney.
That's right.
Wouldn't they used to file,
That never-
switching cases. We had parents that would go to the department, you know, like, I don't want, I can't take it anymore. And then we will have to say that that will be considered abandonment. And they will be charged with that if they were to leave the kid at DCF, or DCF to have custody.
Oh my
I had a case like that on December 24th. That they went, and the day before I was going on vacation, and the mom went like.
Of course, it always
"We
happens
can't
at the
have it."
holidays.
We negotiated, we did as much as we tried, like, come on, let's do a safety contract, whatever. No, here, you can have it. And she was, actually, it was an abandonment issue, and then she ended up having custody back.
She got custody back?
Yeah. And it's very interesting. Yeah.
She could afford Christmas gifts that year.
A year after she was fired for custody, because she wanted custody back because DCF was not treating her daughter right.
Uh-huh.
And she did, she got custody back. And custody back of her daughter and her grandchild that was born. Well,
So it was like the Sissy Harrington case that you guys just did. A joke.
When you read the case, it specifically says each time there's an order that it's if the judge has, could take away the parental rights. It doesn't say that every Chins case gets one, though that is an implication in every Chins case. So in reality, every time there's a Chins case, does the parent get?
Who was with me in court when Ilya's, my friend Ilya got appointed that very day for a Chin's mom, and the Chin's mom was really decompensated and was outside under the stairs, and we had to call 911. Was no one here? I thought there was a student with us.
Maybe it's Kate.
What
No?
do you mean? What do you mean?
Well,
Her looking the ball.
the case came in as a Chin's, as a Chin's case, and I forget why. Because the department was going to be involved, so that day, Ilya got appointed, spoke to her client, and her client was quite agitated. But they were the judge actually made an order allowing mom to have custody, allowing mom to have custody, but again, there was the implication that DCF was going to be involved, therefore the parent was allowed an attorney. She just couldn't get it together, and the judge had already ordered, that's what it was, had already ordered custody of the parent, but the parent had lost it after we walked out of court. So the question then became, who brings it back in to the judge? So that was, I thought somebody was with us that day that experienced that.
The parents
So,
had to be evaluated
yes.
for mental health to see if.
Yeah, she was taken away
Gonna hurt
an
herself
ambulance.
or somebody or
Uh,
something.
Right.
But, and so she's taken away, and child was going to leave with her.
Oh.
So, exactly.
So is the answer that the mother didn't have an attorney?
The mother did. She was
Okay.
appointed that day. She just met her, literally a half hour ago, or, an hour ago, or whatever. And so that's what happens. When the Hillary appointment comes to you as parents' counsel, you're literally meeting them right there in the courtroom. It's like, counsel, do you want a Hillary appointment, basically? I'm appointing you, on this case. So you really have much to say, although attorneys are welcome to appointments these days for financial crisis, but also you have very little time to, figure out what to do. But there are examples of, you laughed about parents waiving. There are many examples of parents, waiving the right to counsel. And that's a whole other thing. Even though these people are adults, the court also has to be clear, satisfied that waiver of counsel, even though it's coming from an adult, is done intelligently and so forth. Karen?
2 questions. So the presumption now after Hillary is that every parent is going to get
it. Only if it looks like DCF's going to be in the picture.
Okay, and that's up to the judge's discretion?
No. It's appointment. Following Hillary, it's mandatory. If the counsel is counsel's appointed, and then parent can waive counsel.
And prior to Hillary, no parents raised this issue?
No parents raised this issue, except for Michael Kelly's clients. Yeah, can you imagine? I mean, the Chin statute was what, early 80s, late 70s, maybe? Something like that, when the Chin's cases started.
So it was on Michael Kelly's?
Yes. Yeah.
Position report.
Just real quick, because we will get to delinquencies too, so as we're going through these Chin's cases and they become sort of more criminal, I just want to think ahead. Obviously, when we get to delinquency, there's delinquency and there's youthful offender, and we'll talk about that in much more detail. But obviously, the child has a right to counsel. Burden of proof is beyond a reasonable doubt. The agency not only is DYS, but could be the Department of Corrections if it's a youthful offender case. So the jurisdiction of the juvenile court for any child who commits a crime is 7 to 17, and you heard Michael, it might be raised to 18. 7 to 17 for any child who allegedly violates the criminal laws or a town ordinance of the Commonwealth. Now, if a child between 14 and 17 commits an offense that involves the serious threat of bodily harm and there's gun laws and so forth, the Commonwealth has the option to file a youthful offender indictment. And before, what year was that now? 1996. I might be wrong. We'll get into that in more detail when we get to those, but some of the cases that you will be reading are under an old procedure that many states still have, and that's the transfer laws. So you might have heard that term about children getting transferred to the adult system for trial. We don't do that anymore. That statute repealed the old transfer laws. Instead, trial is held in the juvenile court, and then the juvenile court judge, after a youthful offender trial, has the option under the dispositional alternatives to give a straight juvenile sentence, which would be DYS, or a combination sentence, which is DYS and then Department of Corrections when you're of age, or what's called the sentence required by law, which is a straight adult sentence, which again, and Leslie had asked the question of Michael, you wouldn't actually be housed with adults because you are a juvenile, but it is a department, you're still under the Department of Corrections. The only exception, and I'm just saying this really quickly now so you just have an idea, but the only exception to the juvenile court's jurisdiction over crimes committed by juveniles is the murder cases. And if a child gets charged with committing murder and the child is between 14 and 17, the juvenile court doesn't have jurisdiction. The child is going to be appearing before the Superior Court as an adult trial. And if the child is found guilty of first-degree murder in Massachusetts, it's a mandatory sentence state, so, and the punishment is life. As you know, when we'll get into that, the Supreme Court had just heard cases on life without parole for juveniles, and there has been movement in Massachusetts around that as well. But the Chintz cases that I want you to read for next time, you know, involve are much more of a serious nature, and they border on the delinquency as well, and they border on bullying and issues like that. So it's a nice sort of introduction to delinquency too. So we'll do that next week, and look for the hypo that I'll send you, Stephanie.
I don't know if you can answer this question, but I was just gonna ask, because it's very interesting to hear. What is your view on whether the juvenile mandatory punishment for murder is cruel and unusual?
It is cruel and unusual. That's it, okay? That's my view. It's cruel and unusual, and I base it on, it's very simple, but it goes up to scientific. And it's a whole reason for the juvenile court in the first place. Kids and adults are different. That was, again, the reason for the juvenile court starting back in 1899. And there's been this sort of slow movement to treat them like adults. And I think I told you first class in England and even in early United States and other states, if a 7-year-old stole someone's purse, if an adult could be hanged, that child could be hanged as well. And there would be no reason ultimately for a juvenile court in the end. So we're going to read Nicholas B., PSP School Committee. Really that's it, because I want to send you the hypotheticals. It's the Hallie Wright that's already in your materials. And I will be sending you a case that we're going to work with that goes back to the whole gay rights issue that I mentioned that we skipped way back. Karen?
So for planning for next week,
Right.
we do the reading, the student suspension reading.
Yes.
And then for Thursday, are we gonna keep going with the syllabus more reading, or are we gonna be working on the Hallie Wright and your hypothetical?
We may have another speaker for Thursday.
So
I'll let you know, but
So we just need to read student
Yes.
suspension and Hallie Wright.
we may start delinquency on Thursday. I kind of doubt it.
Okay.
All right?
Yeah.
And notice that all I wanted you to do at first for delinquency is just go through the dang statute. Okay? Yeah, the dang statute.
Okay.
All right?
Awesome. Thank you.
All right.